Welcome to EPG Pathshala. I am Dr. Vinita Sondi, Associate Professor from Vivekanand College. We will be discussing application of psychology in court. Let us first begin with a brief introduction to the application of psychology in court. This module provides an introduction to forensic psychology, which involves the application of psychological principles to the courts. Psychologists have provided expert testimony in the courts since the beginning of the 20th century, when they testified mainly on eyewitness evidence and criminal personality. The 1950s was labeled the forensic stage by law, as the involvement of psychologists in courts increased dramatically. Psychologists presented expert advice in diverse areas, including mental disorders, influence of pretrial publicity, and the effects of pornography on adolescents. Since then, the role of the forensic psychologist has widened considerably. Howard observes that there are 4 different tasks of a forensic psychologist. The first task is to use various assessment tools to aid court proceedings. For example, to find out whether the person has mental illness and is responsible for his actions. The second task is to perform scientific research in order to provide further information about the case. For example, whether a person could attend to an object despite a lot of distractions during the crime. The third task is as an actuarial, which involves providing statistics for a case, and the fourth is as an advisory. In this role, he may advise the criminal investigation team as to the steps that need to be undertaken so that the progress can be made in the case. For example, how best to interview a witness so that a detailed and more accurate account can be obtained by him. There are certain learning outcomes that are expected out of the module. Upon completion of the module, students should be able to demonstrate an in-depth understanding of the behavior of jurors, critically discuss factors affecting eyewitness testimony, describe appropriate ways of conducting an investigative interview. Let us first consider the justice systems in the world. There are 2 basic systems of justice, the adversarial system and the inquisitorial one. The adversarial system, followed in the US, Britain and even India, a few countries, relies on 2 sets of lawyers, one for the defense and one for the prosecution. They present their arguments, evidence and witness in front of a relatively passive and impartial judge or jury. In the inquisitorial system, followed in countries like France, the judge takes a much more active role, steering and searching for evidence and questioning the evidence. The publication of Hugo Münstersburg's book in 1908, On the Witness Stand, Essays on Psychology and Crime, provided an impetus for applied psychologists to conduct research on the courtroom, including the behavior of jurors, and since then, psychologists have been involved in many issues of relevance in the court. Some issues investigated by them will be discussed next. The first issue regarding juries is that of jury size. In the US system, a panel of about 6 jurors is assigned to a courtroom. This is in contrast to the British tradition, which allows for a 12-person jury. Research tried to investigate if there was a functional difference between 6 and 12-member juries. Classical studies by Ash in 1951 demonstrate that if there was a single person in the group whose views did not match with those of the group, then this person would change her views to conform with those of the group. This was the case even when this person felt that she was correct. This tendency to conform was observed in groups of size greater than 4. Ash also noted that when this person had a single ally in the group, then this tendency to conform reduced considerably, irrespective of the group size. However, the US Supreme Court concluded falsely from Ash's study that a juror in 5-to-1 split faces the same pressure to conform as does a juror in a 10-to-2 split. They concluded erroneously that juries of 6 would perform the job as well as juries of 12. Ash's study had in fact demonstrated just the opposite. The pressure of the individual to conform in the 10-2 split is much less as one gets the support by another dissenting partner, while in the 5-1 split, one has to face the majority alone. Sachs and Marty in 1997 conducted a meta-analytical study which indicated that a member jury behaved very differently from 12-member jury, and they were not functionally equivalent. The study also favored 12-member juries, though 6-member juries too had some advantages. It was observed that jury size tends to have a greater impact on the deliberation process than on the jury's verdict. A 6-person jury took less time and reach a verdict than did a 12-person jury, as they tend to deliberate less. The study also indicated that juries of 12 recalled much more evidence accurately and generated a large number of arguments. They were also more likely to contain members of minority communities and hence were more demographically representative of the community than 6-person juries. However, the overall distribution of verdicts, that is guilty versus not guilty, from small and large juries did not differ. Moreover, the study also found support for Ash's research done in 1951 that a juror in a 5-1 split faces much more pressures to confirm than a juror in a 10-2 split. The second issue regarding juries is that of juror impartiality. Considerable research has been undertaken by psychologists to study how beliefs and attitudes of jurors can influence their decision making. This relationship is the key to understanding whether attitudes held by jurors leads to impartial decision making. The relationship between attitudes and behavior is quite complex and is not always straightforward. Studies indicate that attitudes and behaviors are strongly correlated, but this correlation is moderated by a large number of factors. Adson and Fishben, 1977, reported that there is a very high correlation between attitudes and behaviors if both constructs have the same kind of specificity or generality. For example, let us consider the case when a person has positive attitudes towards the environment. This is a general attitude. From it would be difficult to predict which behaviors she would perform. She might recycle, install solar panels on his house or walk to the work, as these are all specific behaviors. Similarly, Schuler and Yami's 2001 study found that in the courtroom, specific attitudes related to a case will predict that juror's verdict. In the same line, Ellsworth 1991 observed that if the juror has positive attitudes towards the death penalty, then there is a high probability that a guilty verdict will be given in capital murder trials. According to Widmar and Schuler 2001, juror prejudices can be of 4 types. First, interest prejudice. This occurs when a juror has personal interest in the outcome of a trial. Second, specific prejudice occurs when the juror holds specific attitudes or beliefs that can result from exposure to the mass media or rumors in community regarding the case. Third, generic prejudice involves prejudice based on general attitudes of stereotypes. Example of this would be sexist views. Finally, normative prejudice. This refers to a juror being influenced by community attitudes and conforming to the perceived norms of that community. We now come to the third issue regarding juries. This is that of juror decision making. How do juries make decisions? In countries where juries are involved in decision making, no one is allowed to enter the jury room, and jurors are expected to keep their deliberations completely confidential. The story model given by Pennington and Hastie 1986 is the most popular model to describe decision making by a jury. According to this model, the evidence that is presented in front of a juror is often in the form of disconnected witness testimonies. The juror tries to make sense of this information by constructing a narrative or a story as to how and what happened during the event. In constructing these stories, each juror will make up his own story depending on the number of factors such as the evidence that was presented in the court, their personal knowledge of such events based on general knowledge, knowledge gained from personal experiences, media, and their expectations regarding what makes a good story. The story model predicts that the story constructed by the juror will influence the verdict chosen by the juror. The model also states that at times multiple stories may be constructed to describe the event, but the juror will choose the one he thinks is a better explanation of the event. If in case both stories seem equally plausible, then the juror will reduce his confidence in both stories. Let us now focus on the issues surrounding the accuracy of eyewitness testimony. When the witness is called to the court, he relies mainly on his or her memory. The primary concern of the psychology of eyewitness testimony has been to determine what factors affect such variables as the accuracy and quality of a courtroom testimony given by a witness. Let us first discuss one of these issues that has been the center of a lot of research, that is the misinformation effect. There are innumerable cases of individuals all over the world who have been convicted of crimes that they did not commit. These innocent individuals were convicted of crimes based on eyewitness evidence that later turned out to be false. What could explain the miscarriage of justice in these cases? Psychologists have done innumerable scientific experiments which indicate that eyewitness evidence, like other physical evidence, is very fragile. It too can be contaminated and distorted. They point out that the way the questions are worded in the interview can have a dramatic impact on eyewitness memory and can at times lead to what is called eyewitness suggestibility or the misinformation effect. Eyewitness suggestibility or the misinformation effect refers to the finding that misleading post-event suggestions introduced after exposure to a crime can alter the memory of the eyewitness. After witnessing an event, the eyewitness is repeatedly questioned by friends, police authorities, lawyers, etc., and may be exposed to intentional or unintentional misinformation. The information that the witness acquires after the crime, perhaps in the course of the interviews with the police officials, is referred to as post-event information. This post-event information may bring about changes in the witness's recollection of the crime or the suspect. Classic series of experiments by Loftus and her colleagues in the 70s have been conducted on the misinformation effect. For example, in one study, Loftus and Palmer exposed students to an event in the form of films showing car accidents. This was called the eyewitness event. After being exposed to the event, they were then asked questions about events occurring in the films. This information was called the post-event information. There were subtle differences in the wording of the questions asked from different students. The questions that were asked from some of the students was about how fast were the cars going when they smashed into each other. Other students were also given questions, but instead of smashed, they were given questions that used the verbs collided, bumped, contacted or hit. Estimates of speed were higher when the question contained the verb smashed as compared to other verbs. The results of the experiment indicated that even subtle changes in the wordings of the post-event questions could affect the memory of the eyewitness. These results could have implications for real-life events, as well as is the case when when untrained officials color the memories of the eyewitness by asking questions worded in a particular manner. Thus, it is highly recommended that police officials should be trained in interviewing techniques. For example, one suggestion routinely recommended by psychologists is that questioning should start with open-ended questions, as they are the least likely to distort eyewitness memory. The second issue that is of importance in eyewitness testimony is the weapon focus effect. Many studies have found that if a witness to a crime sees the perpetrator holding a gun, knife, or any such dangerous weapons, then the witness tends to focus his attention on the weapon. As a result, the witness cannot attend to other aspects of the crime, such as the face of the perpetrator. This tendency to focus attention on the weapon at the cost of other aspects of the crime scene is referred to as the weapon focus effect. A number of experiments have found support for the finding that the presence of a weapon can reduce the accuracy of eyewitness recall about the crime. The third issue that we will be discussing with respect to eyewitness testimony is aging and memory. A large number of experiments have found that young adults have better memories for crime events as compared to older witnesses. Yarmi, 2001, reported that young adults are better at recalling details of the perpetrator, the environment, and actions when compared to older witnesses. Not only this, but older witnesses are more likely to falsely recognize a face as having seen it before. Bartley, Strater, and Fulton, 1991, reported that while young and older adults did not differ in the rates of correct recognition of previously seen unfamiliar faces, they made much more false alarms to faces that had not been seen before. Still, other studies indicate that older witnesses are more susceptible to the misinformation effect. The fourth issue in the area of eyewitness testimony, which has been the focus of a lot of research, is what is known as the own race bias. Meissner and Brigham, 2001, cite the case of Quincy 5, who were 5 black men wrongfully accused by white eyewitnesses of murder and robbery in the year 1971. The white eyewitnesses stated in their testimony that they were confident that they had seen the black men committing the crime. Although no physical evidence was found, yet 2 of the men were convicted of the crime based on eyewitness evidence alone. However, the actual perpetrators of the crime were identified by the defense and linked to the crime based on physical evidence such as fingerprinting and identification of the car's number plate. The black men were then declared to be not guilty. The defense at the time of trial had also called for an expert psychologist who tried to find evidence for cases involving cross-racial identification, where witnesses stated that they all looked alike. However, at that time, there was not much empirical evidence for this, and the court did not admit expert testimony by the psychologist. Psychologists can now identify 2 major problems in this case. First, the initial conviction of the 2 black men was based solely on eyewitness testimony. Secondly, there were white men who were providing testimony for black men, a case which increases the chances of errors. White witnesses often say that black faces seem very similar to them. There is enough research which indicates that an eyewitness is much less accurate when trying to identify individuals from another race, and better at identifying members of his or her own race. The finding that most people are much better when they are trying to identify people from their own race is referred to as the own race bias by Brigham and Malpass in 1985. We now come to another important issue, and that is how can we improve the accuracy of the investigative interviewer. As a result of scientific research in the field, there have been changes in the way police officials interview witnesses and suspects. Gieselman and Fisher, 1997, have developed the so-called cognitive interview, the focus of which is to maximize the amount and accuracy of eyewitness information. There are 4 principles on which the cognitive interview is based. The first principle of the cognitive interview is that of mental reinstatement of the context of the crime. The witness needs to recall the context of the crime and hence is instructed to reconstruct mentally the circumstances of the crime. The context is both internal and external. Internal context may include, for example, the emotions being experienced by the witness during the crime or the thoughts of the witness during the crime. Hence, internal context is with reference to the emotions and cognitions happening inside the witness. External context may include various external aspects of the circumstances of the crime, such as the time of the day, distinctive smells, placement of the furniture, weather conditions, etc. Mental reinstatement of the context of the crime increases the overlap of the conditions that exist when the crime was being observed and the conditions that exist when the crime is being recalled. The greater the overlap in the context of the encoding stage and the retrieval stage, the greater the recall. This principle is in line with the encoding specificity principle of memory given by Tulving and Thompson in 1973. The second principle of the cognitive interview is that of encouraging extensive memory retrieval and reporting. The witnesses should be encouraged to report as many details as possible. Even if the witness says that she does not remember anything of the event, she needs to see the event from a different perspective and even report things that she may find minor or even irrelevant. It is important to use open-ended questions here and allow the witness to speak as much as possible. The witness needs to tell the entire story here, and so her chain of thought should not be broken. The third principle of the cognitive interview is describing the incident in several different orders. The witness is encouraged to start from the beginning of the incident till the end. She may then be told to reverse the order, that is, start from the end to the beginning. She can even be encouraged to begin from the most significant event and narrate the story from that point both forward and backward in time. The fourth and last principle of the cognitive interview is reporting the incident from several different perspectives. The witness is encouraged to view the crime from several different perspectives, like taking the perspective of a witness, a victim, a perpetrator, a bystander, etc. However, some researchers feel that this mnemonic device may cause witnesses to recall more misleading information. The cognitive interview has been revised by Fisher et al. 1987 by incorporating several more psychological principles and making it much more effective. This has been referred to as the enhanced cognitive interview. Besides incorporating the above 4 principles, it includes several social aspects of the interview setting, such as rapport formation and communication. Additionally, it suggests minimizing distractions, encouraging the witness to speak slowly, allowing a pause between the response and the next question, reducing anxiety of the witness, avoiding any personal and judgment comments, using the same language as the witness. The cognitive interview has been found to be successful in many situations, especially when the event has not been so stressful. However, in some cases, it can lead to small amounts of incorrect eyewitness recall, and this may lead the team to misinterpret the evidence in these cases. Let us now summarize the module. The publication in Hugo Munsterberg's book On the Witness Stand essays on psychology and crime in 1908 provided an impetus for applied psychologists to conduct research in the courtroom, including the behavior of jurors. One issue investigated has been if there is a functional difference between a 6 and a 12-member jury. Benefits of small juries include more equal sharing by the members in the discussion, higher satisfaction of deliberations, and the higher level of group cohesiveness. However, juries of 12 people recalled much more evidence accurately and generalized to a large number of arguments. They were also more likely to contain members of minorities and hence more demographically representative of the community than 6-member juries. Research has also been undertaken by psychologists to the study of how beliefs and attitudes of jurors can influence their decision making. The story model is the most popular model to describe decision making by a jury. It rests on the assumption that juries organize evidence in a narrative, story-like format. The reliability of the witness has also been questioned by psychologists. Many factors may affect the reliability of witness evidence. One factor may be the kind of information that the witness is exposed to after the crime has occurred. This distortion in memory after exposure to post-event misinformation is known as the post-event misinformation effect or the suggestibility effect. Other studies have found that if a weapon is held by the perpetrator during the crime, then a witness cannot attend to other aspects of the crime, such as the face of the perpetrator. This tendency to focus attention on the weapon at the cost of other aspects of the crime scene is referred to as the weapon focus effect. Research has also indicated that young adults have better memories of crime events as compared to older witnesses. Most psychologists also agree that an eyewitness is less accurate when trying to identify individuals from another race and better at identifying members of his own race. This effect is called the own race bias. As a result of scientific research in the field, there have been changes in the way police officials interview witnesses and suspects. Psychologists have developed the cognitive interview, the focus of which is to maximize the amount and accuracy of eyewitness information. Thank you.